All right, everyone. Welcome to this session of our Campus Chats and Coffee. I have to re-record it because there was some outside noise going on in my last one due to some local construction. So thank you for your patience in its publication here. I did switch mugs, however, to ensure that, as promised, I'd have a different mug for each session. So my second cup today is this Luke's mug um, for all of you Gillies out there, aka fans of the television show Gilmore Girls. So that's what I'm using for this session. So we're going to be talking about Connecticut's campus legislation. We are in a really unique and good position here in Connecticut that we have various legislation that helps support Connecticut's institutions and survivors of sexual violence. So we're going to be looking through what rights survivors here in Connecticut have. Again, this is exclusive to folks here in Connecticut. However, some other states have similar laws. So if you're watching outside of Connecticut, I would encourage you to look up what legislation you have in your particular state. So we're going to be followed by my good friend Bill here from Schoolhouse Rock throughout our presentation as I explain on his behalf what these different bills were able to do in Connecticut. Public Act 1411 passed in 2014, provided some institutional policies that need to be in place, anonymous reporting mechanisms, public reports that need to be done. We're not really going to delve into that because that's actually our next session. We're talking through public reports. It requires campus resource teams to be implemented, as well as memorandums of understanding with local crisis centers, and also implements various training requirements on college and university campuses. So in regards to these institutional policies, there needs to be institutional policies to deal with instances of sexual violence and intimate partner violence and stalking, regardless of where that instance occurred. This is critically important, given that the Department of Education's final Title IX regulations didn't necessarily protect students who experienced off-campus incidents of sexual violence. However, here in Connecticut, institutional policies must protect students regardless of where the instance occurred. There needs to be concise written contact information for services that are available to victims, regardless of where the instance occurred. They still need to have different services, and that information needs to be provided to them. They must be informed of their rights in regards to where they can report, how to achieve orders of protection, as well as accommodations that can be offered to them, such as changes to their work, academic, or living situations. Some of these institutional policies need to outline disciplinary procedures, such as these procedures need to be occurring promptly. So soon after they're reported, the procedure needs to begin. Trained officials need to oversee this process. There needs to be the preponderance of the evidence standard utilized through these procedures, which is critically important when, again, we look at Title IX, which provided the ability to utilize other standards. However, here in Connecticut, we need to continue to utilize the equitable preponderance of evidence standard. Individuals who go through these procedures can have the advisor of choice to accompany them through that procedure. They must be informed in writing of the conclusion of the investigation. So if there was a finding of responsibility or not, if the investigation has been completed, those sorts of steps. Their identity does need to be protected through these procedures. There also needs to be a summary of employee procedures if they differ from the student procedures, which often they do. So there needs to be a summary of those procedures as they will be followed. And then they also need to document the range of sanctions that can be utilized in a procedure. So in the case that someone is found responsible, what the different sanctions could look like for that individual. Additionally, as I had stated, there needs to be mechanisms for reporting. So institutions need to provide that for anonymous reporting. Often there is some sort of, you know, mechanism for this on their website. However, they also must inform students or employees of obligations under federal and state law. So while there needs to be anonymous reporting mechanisms, there are also different obligations under state and federal law to respond to instances where perhaps there is an active campus safety concern. And if that is the case, they'll unfortunately need to proceed with, say, an investigation into that safety concern for the betterment of the campus, and to respond to any concerns about ongoing safety. So in those situations, they would need to unfortunately continue with an investigation, even if the survivor did not want that to be the case. However, they do need to make it clear what those obligations are. This also developed the campus resource teams, formerly in state legislation. So there are a variety of campus and community personnel that need to sit on this team. These individuals need to be educated in awareness and prevention that is being done on campus. They need to be informed of policies that are on the campus in regards to some of these processes, as well as the laws that could impact Connecticut students and institutions. They need to be trained in a victim-centered response to ensure that they are responding in a way that is victim-centered and essentially follows the lead of survivors and listens to what their needs are. They need to be educated as to the roles of different members who are on their team, including a campus advocate from a local crisis center. And they also need to be educated on diverse cultural backgrounds on campus and how to respond in a way that is informed by their different backgrounds. These individuals on this team need to meet at least once per semester for these purposes, and they need to, at these meetings, review and update protocols when necessary. So all campuses in Connecticut need to have a memorandum of understanding, or MOU, with a local crisis center. This ensures that survivors can access free and confidential counseling and advocacy on campus if they have an experience of sexual violence, if they know someone who has had an experience of sexual violence. But essentially, this is a resource that is available to all students under this MOU. It also establishes further partnership with the institution. The campus advocate does need to be included on the CRT. They need to be invited to those, semesterly meetings. They also need to have trainings between the school and the center to ensure that the school understands the role of the campus advocate, as well as that the campus advocate understands the different roles of the institution. There are also training requirements. So there is a Title IX coordinator, as well as a campus police and safety requirement for training. They need to understand the neurobiological impact of trauma. They need to understand the impact of rape myths and how that can create victim blaming, create environments where survivors feel hesitant to come forward. They need to understand the behavior of perpetrators of sexual violence and how those offending dynamics play out. And they also need to be trained on effective investigation techniques, including, trauma-informed investigation techniques, given the impacts of sexual violence on individuals who may be involved in these investigations. So then in 2016, we got Public Act 16106. This defines affirmative consent in the state of Connecticut as a standard that needs to be utilized through programs and processes on college and university campuses. So as defined in statute, affirmative consent is a type of consent where essentially, it really kind of hits all of these different benchmarks in order to be achieved. This is a type of consent that may be revoked and must be sustained at all steps. So if somebody agrees that they want to engage in a sexual activity, and then they later change their mind, they have every right to do so. Consent must be sustained through the sexual activity. It's the responsibility of each person to gain consent from the other, not someone else's responsibility to, push back if they no longer want to consent, but rather, everybody's responsibility to ensure they sustain consent. A past relationship with an individual is not in and of itself something that can show consent. So just because somebody has agreed to be in a romantic or sexual relationship with another person, at each individual instance of sexual activity, they still need to be gaining consent. Additionally, lack of affirmative consent is no excuse for claiming that they had consent. So if somebody is intoxicated, they still have a responsibility to gain consent, saying that they were intoxicated and therefore got concerned, confused, would not be an excuse as to why they did not obtain consent from another party who was harmed. Somebody who was behaving recklessly in a way that they did not obtain consent would not be an excuse for not obtaining consent. If they fail to take reasonable steps to obtain consent through asking somebody else, checking in with someone else, that would not be an excuse as to why they did not obtain consent. And if they should have known or did know that a survivor was unable to consent, so if that was a person who perhaps, there was a power dynamic in place that kept them from consenting, if they were intoxicated, to an extent where they could not have consented, if that person essentially should have known that there was some dynamic in place that kept that person from consenting, then there would not be an excuse for what had occurred, and stating that they didn't know, right? If that person was having difficulty walking or speaking because they were intoxicated to that extent, somebody would still be responsible even if they stated that they thought that the person was consenting, because they should have known reasonably that they could not. I also want to note as well, in speaking about this affirmative consent standard, that once again, this is utilized within programming as well as in any investigations that occur and any processes that occur on the campus to prove responsibility or not responsibility, in a case. It's also important to note that this is a really great standard of consent. This is essentially a gold standard, right? And how folks should be operating in an ethical way. So while it is what many individuals would describe as this high standard, this is really an ethical way of behaving in sexual activity. So we are really glad that this is the standard that's utilized. Then lastly, Public Act 2181 was signed into law in 2021. I was at the signing, so that was a very exciting day. So this created annual assessments, or actually biannual. So every other year, these assessments would be implemented. There is a council on assessments that was put in place, as well as amnesty for survivors of sexual violence, as well as witnesses in their cases. So we're going to be talking through these different elements. So the council is developed. There's a number of folks that sit on that council who are able to provide feedback about data points that need to be collected at institutions, tools that can be implemented to collect those data points, as well as implementation recommendations for these data points and tools. So there are many different representatives from different colleges and universities, as well as different community organizations. As the representative from the Alliance, I actually was nominated to be the chair of that council. And essentially what we do is provide all of these recommendations to institutions so that they can implement every other year assessments at the colleges and universities to assess what sexual violence looks like at those institutions, perceptions of safety at those institutions from students, and get some information about experiences of violence that they may have had. It gives these students who are completing these assessments the ability to speak about experiences that they may have had in a way that is very anonymous. So they can give feedback to their institution without having to report. And these assessments, the results of them need to be published after they are completed and available to both the public, but also more directly the Committee on Employment and Higher Education at the LOB. It also has an amnesty provision. This was something that was very important to me as we were pursuing this legislation at the Alliance. But essentially, students or employees who come forward about sexual violence or are witnesses in a sexual violence case cannot experience disciplinary action for the use of drugs or alcohol when they are reporting about an instance of sexual violence that occurred. So if there were drugs and alcohol that were a part of that narrative, if they were drinking or using alcohol when they experienced or witnessed sexual violence, and they need to provide that, as part of their story, right, about what had occurred when they're coming forward, provided that report is in good faith. So it is a true report, which we know the vast majority of reports are. And it didn't put the health and safety of others at risk. So, perhaps they were not doing something that was very harmful to others, such as perhaps, drinking and driving, right? But if they were not putting the health and safety of others at risk through that use, there can be no disciplinary action taken against them. So again, even with those exceptions, this would extend to the vast majority of cases. And so that amnesty is in place for them, which is, again, critically important. A lot of folks didn't come forward because they were afraid they would be punished. They no longer, really can be, because what's most important is whether or not someone experienced sexual violence, not whether or not they or somebody who was there was drinking or using drugs at that time. So our next session, which is the week 5 session, to be recorded on April 22nd, which is today, again, re-recording session number 4. But we'll be talking about understanding public reports. So we're going to talk through the public reports that are prescribed in the 2014 legislation, as well as the Clery Act. Once again, these sessions are recorded on Fridays at 10 a.m. and then they are posted on the following Monday morning on the Alliance's Facebook and Instagram and YouTube accounts. We did skip the session that was set for a Good Friday. Wishing all a happy belated Passover and Easter. But as always, please feel free to reach out if you have any questions. Thank you so much for your attendance today, and I look forward to talking through public reports in the next video.